There has been lots of changes in UK immigration law recently. With us in the studio is an expert in UK immigration law with more than 15 years experience in UK law. Without wasting your time, can you please introduce yourself to the audience?
Hi everyone, I'm Laurentia Kwijiraful. I'm a UK-based solicitor currently specializing in UK immigration law. Thank you very much for allowing me into your homes, your cars, offices, wherever you are listening into from today. Thank you very much.
So Laurentia, before we talk about the recent changes, can you just start by telling us the other changes that are anticipated this year?
Now, on the 4th of April 2024, it's anticipated that there will be a new change in the skilled worker route. Okay, that has got to do with the salary change. So starting from the 4th of April 2024, the salary scale of the skilled workers is going to increase from 26,200 to 38,700. It's important to bear in mind that those on the health and care route, so like carers and all those other ones, are exempted from this particular change. It will not be applicable to them. Now, on the 6th of April 2024, the requirement for a new sponsor for sponsors to renew their sponsorship license is going to be dispensed with. So what is going to happen is they are automatically going to put everyone, all the sponsorship licenses, they are going to make sure they are going to extend it automatically for them to expire in 10 years time. So there will be no need for renewals of those sponsorship licenses. Now, on the 11th of April 2024, I'm sure a lot of people have noticed this. What is going to happen is they are going to increase the income threshold for sponsoring family members. So if you are going to make an application under Appendix SFM as a spouse of a settled person, of someone with British citizenship, now previously you were required to earn at least 18,600. Currently you are required to earn 29,000, and that is going to change. This new rule is going to come in effect on the 11th of April 2024. BRP holders, that is those with biometric residence permits and residence cards, have to take note of this new change. Now, if you already haven't, okay, you must have. If you already haven't received an email, you will be receiving an email from the Home Office letting you know that you have to create a digital account. You are supposed to view your status online through that digital account, because starting from the 31st of December 2024, the biometric residence card and permits are no longer going to be used. So if you look at your biometric residence card and the expiry date is on the 31st of December 2024, you have to start taking measures, you have to start taking steps to ensure that you have created that digital account online, so you are not left out on this new changes coming into effect.
So what about those that have valid biometric card that is still valid beyond the end of this year? Will they still be able to use that card?
Now, what we need to recognize is the biometric cards are fading out. So on the 31st of December 2024, everyone's biometric card will not be able to use a biometric card after the 31st of December 2024. That is why everyone's biometric card currently expires on the 31st of December 2024, whether or not your visa has expired or not. It's just because this applies only to the biometric card, but not to your visa or your status in the country. So on the 31st of December 2024, all biometric cards can no longer be used. They will have to cease using them.
So people that have indefinite leave to remain, that have cards, would they be affected as well?
Now, if you have indefinite leave to remain and it's on a biometric card, you will have to go create a digital account so that it's something like an e-visa. So you create a digital account so you can view your status online. Right. So let's say if you are traveling out of the country, you will have your passport, but you should have access to your digital account as well, so you can prove your status when you are coming back into the country.
Right. Okay. So this digital account is you still be able to carry your passport. And digital account, once you say, for instance, you're coming back to the UK at the point of entry, you will have to show some code for them to access your digital account.
Now, if you have a phone, for instance, you can log on into your account on your phone and then show them your status on your phone. If you don't have it as well, I'm sure they should have a system in place where they can assist you, provided you have created the account. What some people also do is they take a picture of their status. They take they make a photocopy of their status and then they show it there, and that allows them to verify on their system whether they've got status or not.
Thank you very much, Laurentia. So the UK law changes constantly. What advice do you have to give our viewers in relation to this?
Now, I say the law, when it comes to immigration specifically, is not static, it evolves. So my advice to your viewers is keep yourself updated on a regular basis. Now, the Home Office rules, the immigration rules, is published online. If you go to Google and type immigration rules UK, it would all pop up. What you do is you read it as much as you can. Now, if you don't understand it for whatever reason, seek legal advice, let someone assist you. But as much as possible, you have to keep yourself updated with the immigration rules, because they keep changing, so that you don't get any surprises when it gets to you renewing your visa.
Okay, so can you give us the changes that have been implemented in this year and how it will affect our viewers?
Now, on the 1st of January 2024, they did introduce some changes to the student routes. So for instance, not all students, but some students are not currently allowed to let their spouses and dependents accompany them or join them when they are coming to study in the United Kingdom. However, this is not applicable to everyone. So for instance, those who are doing PhD, you can still bring provided if you are doing your PhD, you can still bring your spouses and your dependents. If it's a research program beyond 9 months, you can still bring your spouses and your dependents. So that it hasn't affected all students, but most students will not now be able to bring their dependents. Now, on the 31st of January 2024, they introduced the appendix domestic violence rules. They introduced the appendix bereaved partner routes. They also introduced the appendix statelessness. Okay, these are things people have to know. These are things that people have to know. Now, with visitors, what they did was they relaxed the rules for visitors, in the sense that visitors were not previously allowed to work in this country when they are coming for a visit. However, they can now come as a visitor and still work remotely, provided the main reason and purpose for coming to the United Kingdom is to visit the United Kingdom. On the 1st of February 2024, more countries were added to the list of countries, the non-visa nationals who were required to obtain the electronic travel authorization before traveling into the United Kingdom. That included Saudi Arabia and Jordan, for instance. Now, what they've stated is that by the end of 2024, almost all countries, if not all, non-visa nationals will be required to obtain the electronic travel authorization before they come into the United Kingdom. In February on the 6th of February specifically, 2024, they did introduce something called the immigration, and they did not introduce it, but they increased the fees in the immigration health surcharge. Now, so for instance, if you are making an application for 2.5 years, and proud to this new change, you are going to pay £624 per year. Now you are required to pay £1,035 per year. So the immigration health surcharge alone has been increased by at least 66%. from the 6th of February 2024. Now, it's important for people to realize that not everyone has to pay the immigration health surcharge on top of their applications. Now, these people include those who are applying for citizenship, those who are applying for indefinite leave to remain. And also, if you cannot afford that fees, it's important to know that they've made provision for people who cannot afford the fees by making provision under the fee waiver rules. So that is also something that people can consider. In April, on the 13th, in February, 13th of February 2024, what they did was they increased the fines that normally they would charge an employer who employs an illegal immigrant. Initially, they were charging them 15,000 per person. Now it's been tripled to 45,000. So it's important for employers to note that do your checks very well before you employ someone, because if you don't do your checks very well before you employ someone and they get to you, are going to end up paying 45,000 per person. On the 11th of March 2024, they made changes to the healthcare rules. Now, this change applied specifically to two categories under the healthcare visa route. That was the care workers and the senior care workers. Now, this new change is not applicable to, for instance, doctors, those coming as midwives and nurses, okay? But it applies to only the care workers and the senior care workers. They are no longer allowed, okay, to bring their dependents into the country again. If they want to come here, they can come alone, but they cannot bring their dependents and spouses into the country currently. So those are some of the changes that has occurred in 2024 so far.
Thank you so much. If you've seen my video for the first time, my name is Francis. I do content relating to immigration and different pathways and opportunities to legally migrate. You can show appreciation by giving this video a like. Subscribe to this channel if you want to legally migrate, or if you want any information that can benefit you and your family. Loretta, I just wanted to ask you some questions about the change that have been introduced. Number one, when we say visitors visa can do remote work, am I correct in saying that they can only work for a non-British company?
Now, when I say remote working, it basically relates to, for instance, if let's say you already work as a banker in Ghana, West Africa, for instance, you're coming for a visit. Now, when you come into the country, the main purpose of you coming is for you to visit the country. And of course, visit places of interest and stuff like that. However, you can still work as a banker. Your work, the work that you were doing, you can do that job remotely in your hotel room or wherever you are. That basically is what I'm talking about, yes.
And I also understand that if you are a journalist, say for instance in Ghana, or you are a driver, you're driving, a diplomat, if you come into the country, you can still carry out that duty. Is that correct?
You can carry out the duties provided it's the same thing that you were doing before you came here. So if it allows you to do the work remotely, of course you can do that remotely, yes.
Okay, and just to be clear, because there has been a lot of misinformation going around that visitors visa can now work in the UK. So what we're saying is that those that have visitors visa cannot arrive in the UK, and the next that they are looking for jobs in the UK. Is that correct?
That is correct. Now, it's important to know that there are some visitors who, before you make your application, there are some visitors who were permitted to work already. Okay, so if you fall into that category and you are granted that particular visa that allows you to work as a visitor, that one is fine. But for the general the general people who are coming to visit the United Kingdom under the general visit rules, that one initially they were not allowed to work. But insofar as you come as a visitor and you do your job that you were doing before you came here remotely, that is fine. But you cannot come here and go and look for a job and say, I'm a visitor, I'm looking for a job, I'm working. No, that is not what the law says.
Thank you very much. Can you clarify what you meant by the changes with domestic violence? What does that mean for the ordinary person?
Now, with the ordinary person, prior to this change, people struggled to make applications from outside the country. For instance, if your spouse tells you, maybe for want of better words, I'll just use an example. If your spouse tells you maybe you are called Amma. If your spouse tells you, Amma, let's travel to Ghana, for instance, okay, you travel to Ghana, you get there, and he tells you, he seizes your passport and everything and tells you, I'm not bringing you back, okay. Now, if there were issues with the marriage that dealt with domestic violence, like physical abuse, emotional abuse, financial abuse, if you can prove all those things, you can now make an entry clearance application, okay, as a victim of domestic violence and come back into the country without his assistance.
Thank you so much, Laurentia. So what about the changes that have been announced? Are they going to be applied retrospectively?
No, the changes are not going to be applied retrospectively. When I say that, what I mean is, for instance, if let's say that they are going to change the rules for a spouse, okay, on the for the spouses, the spousal visa on the 11th of May of April 2024, the income threshold is going to increase to 29,000. Now, midnight, okay, a minute before midnight of 11th of May, 11th of April 2024, if you still satisfy the rules as at that time, those rules will be applied to that. That basically means that you still have to satisfy the 29,600, the 18,600. If you made your application before the changes, the new changes will not affect you. What will happen also is that when you are making an extension visa, it's still the same income requirement that you have to satisfy. So it will still be the 18,600 through and through. So what I tell people is, if you know that you are not in a position to earn a higher income, make sure you submit your application before the deadline before 11th of April 2024.
So what about those? There has been a lot of delays with Home Office processing COS. If an employer submits COS before the changes came into effect, would the COS be treated based on the previous threshold?
Now, let me give you an example. There's going to be a new change on the 4th of April 2024 in relation to the skilled salary list. Okay. Now, with the skilled workers, the amount of money, the income and salaries they are supposed to earn. Now, so for instance, if let's say the COS are assigned to a person, okay, before the rules come into effect, the Home Office would consider those applications. However, if the COS are not assigned before the new changes come into effect, the COS will be cancelled.
Sorry, I think because I have a lot of people that have asked me this question. So if the COS has not been approved before...
No. Now, the COS may have been approved by the Home Office, like an employer. And what an employer does is the employer applies for the COS. The Home Office approves and allocates a number of COS to these employers. Now, the employer has to assign it to a migrant for the migrant to make an application. Now, if the employer does not assign the COS to a migrant for them to make the application, and the COS just sits on the table, for want of better words, and they don't assign it, okay, what happens is after the 4th of April, it will be cancelled. Yes.
Right. Okay. What about the ones that the Home Office received, say 3 weeks ago, is stuck in the Home Office and there's changes coming into effect on the 4th of April? Would the changes affect that COS?
They said new application that has not been considered will also be cancelled.
Right. Okay.
That's what, and I think what they are going to do is they've got a sponsorship management system. It's going to be unavailable starting from the 2nd of April to the 4th of April. So on the 3rd of April, for instance, it will not be available. So what I'm advising people to do, especially employers, is to make sure you assign those COS before the sponsorship license system, the management system, is closed.
Okay, thank you. So what advice do you have for migrants who have not yet acquired citizenship in relation to the evolving nature of the law?
Now, with migrants who are not yet citizens of the United Kingdom, what I tell them is very simple. Keep yourself updated. Now, the rules change day in and day out. Okay, so for instance, when you made your application as a spouse of a settled person, if you had to satisfy the English language requirement, and at the point of entry you had the A1 English language test certificate, when you're applying for an extension, you have to get a new one, like the level A2. So you have to make sure that day in and day out you are updating yourself with the immigration rules. You are seeking counsel, you are getting advice from qualified people to let you know what you have to do, what you don't have to do. Now, if you don't seek legal advice, I mean, there are times that people come to us and they actually have messed up. The reason why they have messed up is because they failed to take one small step, okay, in relation to the application. So if they had sought legal advice before making those applications, they wouldn't have ended up in the particular problem that they are in now, that they are looking for solicitors. I mean, always seek legal advice, always keep yourself updated, and always make sure that before you submit any application, you have read the rules through and through. If you don't understand, seek legal advice, because it's better than to mess up your immigration history.
Like we always say at the Launch Club, there is no substitute to information. Knowledge is power. That is why you should consider subscribing to a channel like this, so that you can get the latest update. Laurencia will be with us in a few weeks' time, where we'll be talking about recent changes in British citizens for children born in the UK. So that is going to be a very, very loaded content. If you do not want to miss out on that, make sure you turn on your notification bell so that you will be updated as soon as we come live. Laurencia, is there any other information that you think that with respect to the recent changes that our viewers need to be aware of?
Now, with those on a graduate scheme, okay, it's important to realize that a group has been commissioned, okay, by the Home Office to review the graduate route. Now, they are supposed to bring their report out in May 2024. Now, this group is basically supposed to assess whether or not this graduate route is fit for purpose. Now, no one knows what is going to happen, but if you do satisfy the rules now, my advice is make your application now before the new changes come into being. Now, it may or it may not change, no one knows, but once you qualify and you satisfy the rules, just make sure you make use of it, okay? It's very, very important. And one other thing, there's a new appendix children. Now, this bothers me a little, okay, because one, I'm a mom, I've got 3 children myself. Now, it's difficult and painful seeing children far away in another country and their moms or their fathers in another country. And the only thing keeping them apart is when they are not being able to prove that they have sole responsibility of that child. Now, it used to be quite reasonably easy trying to prove sole responsibility, but currently it is no longer very easy, because the documents that they are requiring, it's like the bar is being raised day in and day out. So I always tell people, when you are making your application, especially if it concerns a child living outside the United Kingdom, seek legal advice, because the documents they are currently requiring is a lot, okay, and it's extensive. So if you seek legal advice, they will be able to guide you as to what documents to put together to show that you have sole responsibility for your child, so that those little children will be able to come and join you to live in this country. Thank you.
So what we're talking about is a situation where, say, the mom or the dad, who is the sole carer for the child, lives in the UK, and they want the child to reunite with them, and the government, it appears that the threshold that the parents have to satisfy to demonstrate that this child is their child, or the children are the children, it's very, very tough. Is that what you were saying?
That is what I'm saying. When you are making an application for entry clearance for a child, you have to show that either both parents are living in this country lawfully, not as visitors, but they are living in this country on another, like not as visitors, but maybe like as parents of a settled child on a settled route, or on another route that leads to settlement. If you are not able to prove that and they are just here as a visitor, that one is a different one. But if if the parents are not both here on eligible routes, okay, you have to show that you have sole responsibility for the child. That is the parents making that application. So if, for instance, the father lives in Ghana, the child lives in Ghana, you are the mom of the child, you've got the birth certificate to show that, look, I'm the mom. You may have done a DNA to show that, yes, I'm the mom of the child. And even the school of the child writes and say that, look, the only person we have on our system is the mother, okay? She's the sole contact we have on the system and everything, okay? So we know the mother as being solely responsible for the child. We have doctors' letters and everything coming up. The Home Office official, whoever it is, may exercise discretion and say, look, I don't and I cannot accept those documents. What you have to provide is a court document to show that you're actually you're actually the sole person responsible for this child. Now, those documents, so you may have to end up going through a family law court for them to assess the child's circumstance before they issue you with a legal document from the court showing that, look, you are allowed to take the child out of the country and you are solely responsible for the child. Now, these ones entails a lot of work. So it's important that you just don't make the application yourself. You just seek legal advice so they can guide you as to what documents you have to put together to make sure that the applications are successful. And I always tell people, if it's not successful at the very first moment, don't give up. Apply for administrative review, because the person who made the application, who considered the decision initially, may have exercised discretion wrongly. What you have to do is always make sure you don't give up. If they refuse you at the very first stage, go to a higher authority. Try as much as possible. Don't give up on bringing the child. Just make sure that you are focused and you are using the right legal advice.
Thank you, Laurencia. If you've seen value for this content, give this video a like and leave your comment in the comment section. Subscribe to this channel for more content like this. Laurencia, it's been a pleasure having you on our show today. We'll look forward to seeing you in a few weeks' time, where you'll be able to give us the breakdown on citizenship for children born in the UK. Thank you so much.
Thank you very much for having me.
Thank you.